Uh, Guys, in our last class, we started the second chapter, second concept also. Before that, we discussed Lee versus Lee Air Farming Private Limited case, where the separate personality of the company has been respected by the court. And court said that though the act was done by the Lee, but it was done in the on behalf of the company, and so law will presume that company appointed or company did that particular act. Then we started the second concept, that whether company is citizen or not, and we discussed that company is not a citizen because the concept of citizen is limited only to the natural person. If you see the words used in the part 2 of the constitution from section 5 to section 11, means any person who took birth, descent, etc., and these are the terms that can be applicable only to the natural person. Rather, section the parliament has enacted even the Citizenship Act 1955, and there it has been expressly excluded. On this particular point, the first case we have discussed is the State Trading Corporation India versus CTO, and the judgment was delivered by the Chief Justice BP Sinha of the Supreme Court at that time. This case is in your case material, though we have discussed, but if you want to even mark or even what you say, mark some para, etc., you can do it. I'm just telling you. पास्ट में तो बच्चे करते थे जब फिजिकल फॉर्म में केस मटेरियल होता था तो यस रंजन सेक्शन 2 ऑफ सिटीजनशिप एक्ट 1955. The first para of this judgment, State Trading Corporation of India Limited versus CTO 1964 for SCR. The first para is about the case history, that how this case reached to the Supreme Court. So it was through the petition, if you remember. Then, uh, after this name BP Sinha, there are point 1, 2, 3. These are the issues. And then you can mark para number 7, para number 7, para number 8, para number 14, para number 16, para number 18. Okay, should I write here? Just give me. It's certain paras that are very important. If you read those paras, then it would be better for you to understand this particular case. 4, not 4, it is 6 for a number. I'm just writing it. Para number 7, para number 8, para number 14, 16, and 18. 14, 16, 18. I just wrote in the chat books. 7, 8, 14, 16, and 18. Okay. In these para, you will find much material that why the Chief Justice P.P. Sinha held that State Trading Corporation, in which there were only 3 members. The first one is the president, who is considered as the first citizen of India, and 2 secretaries in their official capacity. So all these things we have discussed. Now there are 2 other cases that we have to discuss on this particular point. I am taking the second case, and this second case is also again from our Supreme Court. The name of this case is TELCO versus State of Bihar. TELCO is the acronym of Tata Engineering and Locomotive Company Limited. This case is after this State Trading Corporation. You will find on the page number 26. Tata Engineering and Locomotive Company Limited versus State of Bihar, 1964, 6 SCR 885. That means the first is the name of the parties. It was State Trading Corporation versus State of Bihar. यानी स्टेट ऑफ बिहार ने कुछ कांड किया एंड दिस टाटा इंजीनियरिंग कंपनी उसके के अगेंस्ट में जब एग्रीड फील हुआ तो कोर्ट को अप्रोच किया. So this is the name of the parties A versus B. And then there is this second is citation. So this case you can find in the SCR, Supreme Court reports. Okay, Supreme Court report is the authentic journal, or you can say that journal that released by the Supreme Court registry. Okay, AIR, All India Reporter, SCC, Supreme Court cases. These are private journals, journal, and this SCR is the journal issued by the Supreme Court registry, because president also the source of the law. So in the Supreme Court reports 1964 की जो सिक्स्थ वॉल्यूम है, उस सिक्स्थ वॉल्यूम के पेज नंबर 885 you can find this particular thing. So before the advent of information technology, अब तो बस क्लिक करो और गूगल बाबा you can reach you, because that is the search engine. You can directly find that particular thing. You have need not to write the address of that particular document. Okay, earlier this citation were used to be very very helpful. Even now also, if you want to get that authentic printout or read from that particular journal. Here again, this was a very beautiful judgment written by the BB Gajendra Gadkar, who was the Chief Justice at that time this judgment happened. And famous counsel Nani Palkiwala, so he was considered as the courtroom genius. There are many books on them, and many famous cases as argument has been done by the Nani Palkiwala. So Nani Palkiwala is the famous name, and Nani Palkiwala is the petitioner counsel. This TELCO company council. Now see, it is already the decision of the Supreme Court in State Trading Corporation versus the State of Bihar that company is not a citizen. Okay, and the facts are by and large the similar things. So how to take benefit, because whatever already Supreme Court held, that is the law. Okay, so Nani Palkiwala has argued in a different way. Before that, I am coming to the facts of this case. As I have already told in the last class, that in every case, when you read in the case material, or as in the in other for through the other electronic form, you have to see, or you have to find out, or you have to understand that case with respect to the 5 points. The first is the facts of the case. You will find many things written there, but you have to make them brief and understand that these were the facts that, because facts are not changing even in the when the case goes to the higher form also. Okay, then the second thing is about the case history, that how this case reached to this particular form. The third is the issue or the controversy, and the fact also you must understand that are relevant for the decision of the controversy. ऐसा फैक्ट जिसको कंट्रोवर्सी डिसाइड करने में उसका कोई इंपॉर्टेंस नहीं है, उसको याद ना करो, ना उसको ज्यादा समझने या लिखने की जरूरत नहीं है. The fact that determine your decision has to be at least right. Okay, and the fourth one is the arguments. दोनों तरफ से arguments आप लिख लो. And the fifth one is the reason or the decision के पीछे का कारण. Okay, here like in earlier case State Trading Corporation, here was the Tata Engineering and Locomotive Company Limited, well known company. Its acronym is TELCO. This company was a registered company. It was registered under the 1913 Act. And this company was in the business of manufacturing the truck, bus chassis, and the spare parts. Okay, at Jamshedpur, Bihar. Manufacturing is at the Jamshedpur, and the head office was at the Mumbai. Okay, so when and before this GST, the different state have their different tax system. So when this company who is manufacturing its bus and chassis and spare part, and because it has the registered office at Mumbai, that is in the different state, and so the state tax official, they said that it is actually the sale made by the company, and so the sale tax was assessed. And like earlier case, there is a in the earlier case also, there is one provision, article 286 of the constitution, that talk about restriction as to the imposition of tax on sale or purchase of goods. So similar provision was also sought here also by the the telco, and they said that the sale tax is not you know uh, is not applicable here. And the tax officer said that no, you have to pay the sale tax because it is covering under it. The first para of this case, Tata Engineering and Locomotive Company Limited, you will find out this provision. I'm reading that the authorities under the respective sale tax act has rejected the petitioner contention that the transaction in question are interstate sale, and have been held that article 286 clause 1a is not applicable to them. That means the telco was saying that it is just the interstate sale, and so the benefit of article 286 would be applicable. But the sale tax officer has rejected this contention, and aggrieved by this, telco went in the writ petition before the Supreme Court under Article 32, and they there challenge the validity of the demand of the sale tax. Okay, now they want to take the benefit of Article 19, and for that one entity has to be the citizen. Now the company is not the citizen; it is already established by the law by the same Supreme Court in earlier judgment of State Trading Corporation. And so they approached to the Nani Palkiwala. He said that I will take a different plea. Okay. So Nani Palkiwala contended on behalf of the telco that uh, I, request the court to tear the veil of the corporation. That means lift the veil of the corporation. That means you disregard this concept that company is a separate person, and see that behind the company there are natural person who are the citizens, and these natural person are affected by the tax assessment of the income tax official. These natural person are citizen and have the benefit of this thing. And so the Nani Palikiwala said that whether the veil of the corporation can be lifted and the rights of the shareholder of the said corporation could be recognized under Article 20, Article 19 or not. The court said, or you can say the before that the the argument from the sale tax officer that the veil of the corporation cannot be lifted, because in the law the corporation is a separate legal personality. Yes, the affected, ultimately the affected person will be the members of the company, and these members are the natural person. But in the law, when the company is incorporated, it became a separate legal personality, and its personality has to be disregarded. Or you can say, you can lift the corporate veil and see who are actually behind that company only when it is needed. In the next topic, we will discuss this concept of lifting of corporate veil. And there also, it's not that company will, on that particular situation, always company will lift the corporate veil. No, there has to be some requirement. When law is misused, suppose the company is used for evading the tax, suppose the company is used for evading the welfare legislation, and then for the justice, the court say that we are disregarding that the company is a separate legal personality, but we will see that actually behind this company are these person, and these person who are responsible. So this is the main thing. And the after listening the arguments, courts observe that if we allow the lifting of corporate veil by these beautiful argument of Nani Palkiwala, that means we will allowing the same things that we are not allowing earlier. And so court held that this petition, this plea in this petition cannot be allowed, because if this plea was upheld, it would really mean that the corporation or the company cannot achieve directly, can be achieved indirectly by applying the doctrine of lifting of corporate veil. If the corporation and the companies are not citizen, it means the constitution intended that they should not get the benefit of article 19. And when they should not get the benefit of article 19, we by applying, or we by allowing this petition, actually defeating the intention of the constitution. And so the petition was not allowed. Okay, here about the facts of the case. Okay, then the first para also you can read, then second para, and then the most important is the para number 19. No, 29, not 19, 29. Para number 29, I'm reading. Mr. Palkiwala sought to draw a distinction between the right of the citizen to carry trade or business, which is contemplated by Article 19(1)(g), from his right to form the association or union contemplated by Article 19(1)(c). Nani Palkiwala is saying that under Article 19(1)(c), a citizen can form the association. So here also some citizen form the company, that association, that is well known, allowed uh, rights under Article 19. And then Article 19(1)(g)(c), that right to this right to carry the trade, business, etc. And so using these two articles, he said that he argued that Article 19(1)(c) enables citizens to choose their instruments or agent for carrying on the business, which it is the fundamental right to carry on. If citizens decide to set up a corporation or company as the agent for purpose of carrying on trade or business, that is a right which is guaranteed by them under the Article 19(1)(c), basing himself on this distinction between these two rights guaranteed by the Constitution under Article 19(1)(c) and Article 19(1)(g), respectively. Palkiwala somewhat ingeniously contended that we should not hesitate to lift the veil, because by looking the substance of the matter, we would really give effect to the two fundamental rights guaranteed by the Article 19. Why he was saying that lift the corporate veil? That there are two rights given, two liberty, one to form the association, and so here the some persons who form the association, because Article 19(1)(g) says that there is the freedom to do business, trade, and carry on business. And here the persons, the members of the company, they use their instrumentality not in the individual capacity, but by forming the association, and the forming the association is also the right. And so by using these two means that these person who are the member actually use the instrumentality of their the association that is well recognized right under article 191c, and so we must lift the corporate veil to give these person the benefit of article 191g. We not impressed by this argument. Court is saying the fundamental right to form an association cannot in any manner be coupled with the fundamental right to carry on trade or business as it is held by the All India Bank Employees Association versus National Industrial Tribunal. The argument which is thus attractively presented before us overlook the fact as contrasted with the certain other article like 26, 29, and 30 guarantees the right to the citizen. As such, an association cannot lay claim to the fundamental rights guaranteed by that article solely on basis of being aggregation of citizen, that is to say the right of the citizen composing the body and the respective rights guaranteed under article 19(1) cannot be combined as suggested by Mr. Palkiwala, but must be asserted each in its own way and within its own limit. The court rejected the contention that we cannot club two articles together. They have to be read in each in its own way and in own limit. The sweep of several rights is no doubt wide, but the combination of any of these two rights would not justify the claims such as made by Palkiwala in present petition. As soon as citizens form a company, the right guaranteed under the Article 19(1)(c) has been exercised. So when a person form the company, that means they are exercising Article 19(1)(c) to form the association. And so that right has been exhausted and no restraint has been placed on that right and no infringement of the right is made. Once a company or corporation is formed, the business which is carried on by the said company or corporation is the business of the company or corporation and is not the business of the citizen who get the company or corporation formed or incorporated. And thus, and the right of the citizen and the right of the incorporated body must be judged on the footing on that footing and cannot be judged on the assumption that they are the right attributable to the business of the individual citizen. And therefore, we are satisfied that the argument based on the distinction between two rights guaranteed by Article 19(1)(c) and 19(1)(g and the effect of their combination cannot take the petitioner case very far when they seek to invoke the doctrine that veil of corporation should be lifted. That is why we have come to the conclusion that the petition filed by the petitioner are incompetent under the Article 32, even though in each these petition one or two shareholder of the petitioner companies have been joined, and finally it was rejected. And so means the court has said that we cannot allow the lifting of the corporate veil. So this para number 29 is very important, that why the court has rejected the argument for not clubbing article 19(1)(c) and 19(1)(g) and to lift the corporate veil. uh, you know para number 1, para number 2, and para number 29, you at least read these three para. If you are not reading other, if you read whole case, that is what much better. In earlier case also, state trading corporation, para number 6, para number 7, para number 14, 16, and 18, please read these paras if you are not able to read full case. Okay, so with this Supreme Court again held that after formation of the company, citizen use the right provided under Article 19(1)(c), and the citizen have fully exercised their right under Article 19(1)(c) to form the corporation. But when the corporation is formed, it is done by the business has to be, or the activity has to be done, has to be considered as done by the company itself. And then we can, I cannot again clubbed the Article 19(1)(c) with the Article 19(1)(g), and we cannot impose or cannot apply the lifting of the corporate veil concept in directly, or in nutshell, you want to say, you can say that if the court allow this type of the petition, that means the court is allowing that thing, that by that the corporation can achieve indirectly what it cannot achieve directly. And so this is not permissible, this is not uh, allowed. Okay. Any question, any query, any other observation that you want to make from this particular case? Yes, guys, you have 1-2 minutes. Anything that you want to ask? And please read this case. 4 cases we have discussed so far: Solomon versus Solomon Company, Lee versus Lee Air Farming Company. These 2 cases are on the separate personality of the company. State Trading Corporation India Limited versus CTO, and TELCO versus State of Bihar. These 2 cases are on the company is not a citizen. Babita, any question, any query you have?
सर दैट मीन्स अगर इंटेंशन को देखें कि टैक्स से बचने के लिए कोई आ रहा है, कंपनी फॉर्म कर रहा है, तो फिर कॉर्पोरेट मतलब उसको फिर प्रोटेक्शन नहीं मिलनी चाहिए ना,
No,
इसका ये
actually,
सवाल है।
see, actually, see, uh, if you see the scheme of our constitution, part 3 of the constitution has the fundamental rights. Okay. And these fundamental rights are legally enforceable. See, we have the rights under our part 3 also, under part 4 also. Directive principle of state policy are also the in form of rights, but these are not non-justiciable. That means you cannot enforce whatever given in the part 4. And article 36, 37, you if you read, there is clear itself, it is written in the constitution that part 4 rights are the non-justiciable. It's on the state understanding when they will make those available, like the maternity leave. Now, as a law, we have the maternity leave. Part 3, it has a scheme. The word state has been defined under the article 12. Then article 13 also define the law and etc. And article 32 talk about the remedy. Okay. Now, if there is any violation of fundamental right, a person can approach to the Supreme Court by virtue of Article 32. Now, the question is, who will approach to the Supreme Court? The person whose rights are infringed, whose rights are violated. Though there is another concept of the PIL where this traditional concept of the locus standi has been relaxed, and the person whose rights has been violated, if that person is not so much vigilant or not so privileged, then in that case any public spirited person can also file the case. But for the redressal, there must be that there is a right that is covered under the this particular chapter, the fundamental right, and that right has been violated. Like in the law of the tort also we read, injuria sine daminum is actionable. Injuria sine daminum, sine means without, daminum means damages, and injuria means legal injury. So if there is a legal injury without damages also, that is actionable. And the Bhim Singh case where this person was restrained by the police officer and he was not able to cast the vote, it was actionable. And so for approaching to article under article 32, one has to show that this was a right, legal right, and this has been violated. The freedom of trade and business provided under Article 19(1)(g) is given only to the citizen. Okay, and the company in the state trading corporation and the telco want to take benefit of that in compliance with the Article 286. Okay, now this right of Article 19(1) G is available only to the citizen, and so their argument is that our company is also citizen. In the first case, it was held that even because the president is the member of the company, and other secretary is also the Indian citizen, so company is also citizen, and please give please accept the writ petition, because if you are not able to show that fundamental right is violated, your writ petition would not be maintainable. And here in this case also, finally writ petition has been is defeated, because company was not held to be by any means, it was not held that in this particular situation there was the violation of the fundamental rights provided under Article 19(1)(g). कोर्ट सेड कि जो आपके मेंबर्स हैं उनको आर्टिकल 19(1)(c) का बेनिफिट मिल तो गया. If that has been made, now that thing done by the state, the sale tax action taken by the state is not affecting to you this, it is against the company, that is the separate person. Okay, so Babita, basically this is on this particular point hitting. Yes, any other question, query? Yes, Abhishek.
सर मेरा एक सवाल था सर, पता नहीं सर कितना सही है कितना गलत है, लेकिन सर मुझे ये पूछना है, मान लीजिए कंपनी की जगह कोई पार्टनरशिप फर्म होती तो सर ये अप्लाई कर जाता कि उसमें तो पार्टनर्स एज अ मतलब एक नेचुरल पर्सन है मान लीजिए, तो तब तो सर ये बेनिफिट मिल जाता टैक्स का.
Right, right. Yes, because partner, because the partnership is, if you see Section 4 of the Partnership Act, it says that it is a relationship. Okay, and firm is the collective of the partners. So it is a compendium of the partner. Firm is not a separate legal personality. Firm is only the collection of the persons. And so the firm is, as I've said, that is just a collection of the individual who are the citizen, who has their well established right under Article 19(1)(g). And so in that case it had been approved. Yes, writ petition वो उनकी accept हो जाती है.
सर एक सवाल और था सर. सर जैसे मान लीजिए कि एक फर्म बनी पार्टनरशिप फर्म, पार्टनरशिप फर्म में सर सेक्शन 4 कहता है कि पर्सन्स होने चाहिए, पर्सन्स में ज्यूरिस्टिक भी हो सकते हैं और नेचुरल भी हो सकते हैं. अब लेकिन मान लीजिए सर उसमें से कुछ नेचुरल है और कुछ ज्यूरिस्टिक हैं, तो मतलब तो किनको बेनिफिट मिलेगा?
नो नो नो, if your members, if your partners are not natural, no, I said that if the partners are the natural persons, they can get that. But if your partners are itself are not natural, just the two company have the partnership, then that would not get.
नहीं सर, मेरा ये कहने मतलब नहीं था, मान लीजिए पार्टनरशिप फर्म बनाई है, मतलब 8 पर्सन हैं सर, 8 में से 4 हैं क्या कहते हैं ज्यूरिस्टिक पर्सन और 4 हैं नेचुरल पर्सन, और सर पार्टनरशिप फर्म बनाई गई है. अब सर क्या है कि जैसे मान लीजिए कोई टैक्स की कोई लायबिलिटी है, तो उसमें जो ये बेनिफिट मिलेगा आर्टिकल 19 का, वो सिर्फ उन्हीं 4 पार्टनर्स को मिलेगा जो नेचुरल पर्सन हैं, बाकी जो 4 ज्यूरिस्टिक हैं उनको तो नहीं मिलना चाहिए.
नो, because their rights has not been defeated, because they don't have the right. जब आपके पास right ही नहीं है, natural person have the right, but these other persons who are the juristic person and the member of the partnership firm, they are not the natural person, so their right has not been infringed by affixing the tax, and so only those person got the things, and so that much of the you can say is things enforceable. The benefit will be get only the natural person but not the artificial person.
हाँ सर, मेरा मतलब ओवरऑल इफेक्ट तो नहीं होगा, मतलब ये होगा कि जितने नेचुरल हैं उनको बेनिफिट मिलेगा और जो ज्यूरिस्टिक है उनको इफेक्ट मतलब उनको बेनिफिट नहीं मिलेगा इसका.
Yes, they have to be the things.
Okay, thank you very much, sir.
Okay. Now there is another case that is given here. It has not been provided, and the name of this case is R.C. Cooper versus Union of India. R.C. Cooper versus Union of India, 1970, third volume, 3 SCR. Third 3 SCR means third volume of Supreme Court reports of 1970, page number 530. R.C. Cooper versus Union of India. लिख भी देता हूँ मैं. So it's R dot C COP Cooper versus yes, ask the question. Anyone who raised, if want to ask, please ask the question. Who raised the hand? किसने हाथ किया था अभी? I just written in the chat box R.C. Cooper versus Union of India 1973 SCR. This case you also study under the constitutional law case. This is the famous case known as the bank nationalization case. I think you know that the Indira Gandhi government did the bank nationalization. So this is about that case, the legality of that. And the facts of this case, that in 1951, when India just got independence and got its new constitution, there were 569 banking institutions, the commercial banking institutions. And after that, by merging the many banks, the Central Bank of India came into existence. And in 1969, there were only 89 banks along with the Central Bank of India. And providing accessibility of the bank to the rural areas, the government thought that there should be the nationalization, because the company or the banking corporation has to be work there where they get the profitable business. Okay, because in the cities at that time there has to be more commercial activities. Rural area were very backward, and so the most of the these banking institutions were settled in the urban areas, and government, to get the benefit of the banking sector to the rural folk, devise a method that they should do the nationalization of the bank, and then when they get the nationalization of bank, then they can open the branch in the rural area also. The concept of the rural bank, Gramin Bank, we all have, like in my place it is Gurgaon Gramin Bank. So all these things were possible when the nationalization is done. And the government thought, and the government passed a legislation. And by that legislation that government passed in the 1969, government acquired 14 banks. The name of that legislation was earlier it was through the ordinance. The government, as a research like the Modi did this time with the, the farm law. So they first come up with the ordinance. The president promulgated the ordinance. Banking companies acquisition transfer of undertaking ordinance 1969, and by this ordinance 14 banks were nationalized. These 14 banks were chose on the basis that they has the deposit exceeding the 50 crore rupees. On that basis, the bank were find out जिनकी income 50 crore से ज़्यादा थी, and they were 14 in the number, they were find out. And to that, the law has been promulgated by the president, the law making power of the president under Article 123 of the Constitution. With this ordinance that covered 14 banks, nearly 75% of the banking sector was come under the state control, along with their asset, liability, and entire paid up capital. After 2 days, the same ordinance the government came with the in the parliament, and that was passed. Now in this, though it was a very good step, if you see, but the problem was that that government devise a method that if we uh, how will we will get compensation, because government was acquiring the bank. Okay, so government has to give the money, and for that there has to be the settlement, the agreement, or the round of talk between the bank and the government, and a price or a consensus has been made on which the bank property of a particular bank has to be acquired, the asset, paid up capital, etc. If that is not possible, if there is not agreement reached between the bank and the state, the government, then what would be the consequence? And so the government in the second schedule of this particular legislation has made a very interesting, or you can say horrific provision, that uh, if the bank and the government has not come up at a particular uh, agreement for finding out the compensation price, then it would be decided by a tribunal, and the amount this tribunal would decide would be given to the bank after the 10 years. Okay, so it is just the duress or the pressure by this particular provision government is making. Now these are the facts. Now there is one influential businessman, like all these Tata etc., Rustam Karsji Cooper. So this man RC Cooper, he had the majority shareholder in uh, two banks who were also in the list of 14 bank who got acquired, the Central Bank of India and Bank of Baroda. And now this person wants to, you know, file the writ petition. That one is that it is a violation of Article 14, it is a violation of Article 19, all those things, because we have the freedom to do business. Hamara business you are taking. So this is not proper. But before you knock the door of the Supreme Court that there is a and come under the Article 32, you have to show that your fundamental rights have been violated. And so, Mr. Rustam Karsji Cooper filed the writ petition under Article 32 and contended the violation of Article 14, 19, 1F and the Article 31 Clause 2, that is earlier regarding compensation, etc. Now, the issue here is whether a shareholder can file a petition for remedy against the violation of his legal violation of his fundamental rights provided under Article or you can say Part 3 of the Constitution, when the action is against the company in which he is just a shareholder. And the court, it was the 11 judge bench decision. Out of that, only Justice A.N. Ray gave the dissent opinion. 10 judgment gave the judgment against the Mr. R.C. Cooper and in favor of the government, because that time even the judiciary position was not, that good. The government want that judiciary that give the judgment in favor of the government when the government is doing the activity for fulfillment of the rights provided under the Part 4 of the Constitution. And government was saying the committed judiciary. We want committed judiciary. So government argument, this is something out of the track I am telling. Uh, this is the government stand was that what we are doing is good for the people. We are giving the banking facility to the rural area, and this thing can done by this way particular way. So the part 4, the directive principle of state policy DPSP, there are certain things that were left on the government, the prudence when they would be make applicable. These are not just justiciable. So government opinion was we are enforcing those things, giving benefit, and this fundamental rights, because there were a long time there were the tussle between fundamental right and the DPSP. So here also government saying we want to give the fulfill our commitment under part 4, but then there is the hindrance by the part 3 constitution, part 3 fundamental rights. Okay, here the Supreme Court, I'm just telling in the nutshell. This case you can find out through the internet, or the case comment you can find out. You will not get in the your case material, or you can go to the Supreme Court and find SCR, और ऑनलाइन भी SCR मिले तो उस पे कर लो, या आप वैसे ढूंढ लो. Majority decision, it was the decision 10 into 1. Supreme Court held that shareholder or director cannot move to the court for the protection of the infringement of the fundamental rights of the company unless it is proved that by impugned action his fundamental rights are also violated. And here what they are claiming, that freedom to do the trade or business is available to the particular person and not to the company, and this action is against the company but not to you. And so, in this case also, the Supreme Court has held that company is not a natural person, and the partners, sorry, the members or the shareholders or the director cannot approach by saying that, the same type of the argument as done by the Nani Pal wala, that under Article 19(1)(c) we through the association we want to do the business, and then we have the fundamental right under Article 19(1)(f). So it is nothing but through this instrumentality we are exercising our right provided under Article 19(1)(f). Court says that you have no locus standi because your fundamental rights has not been violated, though indirectly you will get the effect of it. But in the law, the company is a separate person and company is not citizen, and so the writ is not maintainable. So all these three cases, State Trading Corporation India versus TTO, TELCO, Tata Engineering and Locomotive Company versus the state of Bihar, and this RC Cooper versus Union of India. All these cases are on the point of that the company is not a citizen, and whenever the action is taken, or you can say the shareholder cannot take the benefit that the any action taken against the company is against them, and there is the violation of their fundamental rights. So with this particular concept is over, this particular topic is over, like the whether company is citizen or not. In the next class, we will discuss the lifting of corporate veil. Lifting of corporate veil, or piercing the corporate veil, or tearing the corporate veil is not a very difficult concept. The name is very fancy. That means, if you see the meaning is, suppose there are two person who form the private company like ली versus ली एयर फार्मिंग. लो ने कहा कि हम इन दोनों को नहीं देखेंगे, इनकॉर्पोरेशन के बाद में इनके ऊपर एक चादर ढक दी, एक वेल लगा दिया कॉर्पोरेशन का, और अब ये एक अलग चीज के नाम से जाना जा रहा है. ओके, ठीक है. यहाँ पे इसका मतलब ये हुआ, इन दोनों आदमियों की पर्सनैलिटी के अलावा कंपनी की पर्सनैलिटी जो लॉ के फिक्शन से बनाई है, वी आर गिविंग रिगार्ड, सम्मान टू दैट पर्सनैलिटी. ओके, when we are not giving the regard or disregarding the company's separate existence or separate personality, उस केस में हम ये कहेंगे कि that is lifting of corporate veil, tearing of corporate veil, piercing, piercing of corporate veil. Okay, so whatever we read earlier, जो Solomon versus Solomon company, Lee versus Lee Air Farming Company, State Trading Corporation versus CTO, TELCO versus State of Bihar, RC Cooper versus Union of India, whatever we read, यहाँ पे उससे उल्टा देखेंगे, उससे अपोजिट वी विल डिस्कस. यहाँ पे कहेंगे नहीं, कंपनी नहीं, एक्चुअल में दीज आर्मी हैज डिड, बट देयर हैज टू बी सम नेसेसिटी कि कम हम लिफ्ट करें. अदरवाइज द वेरी पर्पज ऑफ सेक्शन 9 ऑफ द कंपनीज एक्ट will be defeated. पूरा चैप्टर 1, पूरा चैप्टर 9 जो है वो आपका सेक्शन, सॉरी, पूरा चैप्टर 1 जो है वो आपके सेक्शन 9 और सेक्शन 3 का पहला वो जो 3 क्लॉजेज है उसी पे डिपेंड है, केवल यही 2 सेक्शन में हमने किया है. एंड सो मेनी थिंग्स वी हैव डिस्कस सो फार. So with this, today class is over. Any query, question, remarks, anything you want to ask, please, you are liberty to ask. Yes.